Hey y'all, welcome to That Tennessee Feeling. How is everybody today? Thanksgiving's gone. Christmas is coming. It's cold. Welcome to December in Tennessee. I hope everybody had a great week. I do hope you guys had a great Thanksgiving. Got to spend time with family. If you worked, then I hope your work family was as amazing as your normal family, if not better. I get both of those. Thanks to everybody who still listens to this podcast. It is still monthly. It's probably going to continue to be monthly for right now due to schedules and life. But I appreciate everybody who still listens in. You guys are awesome. So today I want to talk about something that is actually kind of historically big in Tennessee. And you've probably heard of it if you've ever studied pretty much any type of history in Tennessee. You've definitely heard of it, and you've probably even heard of it in U.S. history. And if you've ever studied criminal justice or law, you've heard of this. And that's the Scopes trial. That's right. The Scopes trial, or the Scopes monkey trial, was an American legal case from July 10th to July 21st in 1925, which took place in Tennessee. The actual case's name is the State of Tennessee versus John Thomas Scopes, i.e. the monkey trial. And so why did this happen? Why did we have a monkey trial in Tennessee? Well, high school teacher John T. Scopes was accused of violating Tennessee's Butler Act. Okay, well, what's the Butler Act? So, the Butler Act comes from John Washington Butler, who was a Tennessee farmer and a head of the World Christian Fundamentals Association. He actually lobbied the state legislature to pass anti-evolution laws. He did not want evolution to be taught in the state of Tennessee. And he actually got this passed in March of 1925. Now, it should be noted that Butler stated later he didn't know anything about evolution, and he had read in the papers that boys and girls were coming home from school telling their mothers and fathers that the Bible was nonsense. And he decided that he didn't like that, so he wanted to do something about it. Tennessee Governor at the time, Austin Peay, signed the bill to gain support among rural legislators, but believed that the law would be neither enforced nor interfere with the actual education in Tennessee schools. William Jennings Bryan actually thanked Peay enthusiastically for the bill, stating, "Christian parents of the state owe you a debt of gratitude for saving their children from the poisonous influences of unproven hypotheses." Welcome to the state of Tennessee. A man who had no idea what evolution was, lobbied against evolution, and got it passed on the basis and fear that people were not going to be Christians because they came from monkeys. No idea. Yeah. So when this happened and when this law passed, the ACLU, or the American Civil Liberties Union, actually financed a test case in which John Scopes, i.e. the Scopes and the Scopes monkey trial, he was a Tennessee high school science teacher at the time. He agreed to be tried for violating the act. Scopes, who had substituted as a biology teacher, was charged on May 5th, 1925, for teaching evolution from a chapter in George William Hunter's textbook, Civil Biology, Presented in Problems. And this described the theory of evolution, race, and eugenics. And by the way, eugenics is a set of belief and practices that aim to prove that the genetic quality of the human population. Basically, they're inferior in, Darwin's, the fittest. Yeah, the survival of the fittest. That's eugenics, technically. That certain gene pools are better than others. Now, John Scopes agreed to be tried, and the two sides brought together the biggest legal names in the nation, and the ACLU was backing John Scopes. Bryan for the prosecution, and Clarence Darrow for the defense. And this trial was #1 top hot news, putting Tennessee directly in the spotlight, for good or for bad reasons. This case happened in Dayton, Tennessee. Now, the ACLU offered to defend anybody accused of teaching the theory of evolution in defiance of the Butler Act. And on April 5th, 1925, George Rappalia, a local manager for the Cumberland Coal and Iron Company, arranged a meeting with the county superintendent of schools of Walter White and a local attorney, Sue K. Hicks, at Robinson's drugstore, convincing them that the controversy of such a trial would give Dayton a much-needed publicity. So one person wanted to do it to prove it was right or wrong, and one person just wanted to get Dayton, Tennessee on the map. So they met and they summoned 24-year-old John T. Scopes, a Dayton High School science teacher and math teacher, and asked him if he would admit to the teaching of the theory of evolution. Now, Rappalia pointed out that the Butler Act prohibited the teaching of this theory of evolution and that the state required teachers to use a textbook that explicitly described and endorsed the theory of evolution, and that teachers were therefore effectively required to break the law. So basically, what it means is that they passed the Butler Act stating you cannot teach evolution in the state of Tennessee. Well, that's well and good, but you still have a textbook in the state of Tennessee that you are requiring teachers to teach from, and including buying them with state-funded money that includes the teaching of evolution. Tennessee obviously didn't do their homework. Now, Scopes mentioned that while he could not remember whether he had actually taught evolution in the class, he had, however, gone through the evolutionary chart and chapter with the class. So it had been mentioned. And Scopes added to the group, if you can prove I've taught evolution and I qualify as a defendant, I'll be the one to stand trial. So they set out. They had their homework. Scopes urged students to testify against him and coach them in their answers. And he won. He was indicted on May 25th after 3 students testified against him at a grand jury. One student afterward told reporters, "I believe in part of evolution, but I don't believe in the monkey business." Judge John T. Ralston accelerated the convening of the grand jury and all but instructed the grand jury to indict Scopes, despite the limited, meager evidence against him and the widely reported stories questioning whether the defendant had ever actually taught evolution in the classroom. So basically, these people are steamrolling this case. They want to be tried. They want to be tried now, and they wanted to be tried in Dayton, Tennessee. So Scopes was charged and charged on the violation that he taught evolution in a high school class against the Butler Act, and was nominally arrested, even though he was never actually detained. Paul Patterson, owner of the Baltimore Sun, put up the $500 in bail for Scopes just to get the ball rolling. Now, the original prosecutors were Herbert He and Sue K. Hicks. 2 brothers. That's right, y'all. Boy named Sue. 2 brothers who were local attorneys and friends of Scopes, but the prosecution was ultimately led by Tom Stewart, a graduate of the Cumberland School of Law, which is in Lebanon, Tennessee, who later became a U.S. Senator. Stewart was aided by Dalton attorney Gordon McKenzie and supported the anti-evolutionary bill on religious grounds, describing evolution as a detrimental to our morality and an assault on the very citadel of our Christian religion. Now, I don't talk politics, but I will say that sounds very familiar to things going on to this day. Except we're not talking about monkeys. Now, back to the case. Hoping to attract major press coverage, George Rappalia went so far as to write British novelist H.G. Wells to ask him to join the defense's team. Wells replied that he had no legal training in Britain, let alone in America, and declined the offer. John R. Neal, a law school professor from Knoxville, announced that he would act as Scopes' attorney whether Scopes liked it or not, and he became the nominal head of the defense team. Baptist pastor William Bell Riley, the founder and president of the World Christian Fundamentalist Association, was instrumental in calling lawyer and 3-time Democratic president nominee and former U.S. State Secretary and lifelong Presbyterian William Jennings Bryan to act as the organization's counsel. Now, Bryan had been invited to Sue Hicks' house to become an associate of the prosecution, and Bryan's had readily accepted, despite the fact that he had not tried a case in 36 years. He was a little rusty, but he was down for it. As Scopes pointed out to James Presley in the book Center of the Storm, on which the two collaborated, after Bryan was accepted by the state as special prosecution in the case, there was never any hope of containing the controversy within the bounds of constitutionality. So basically, as soon as this person took this in to prove that, evolution was wrong and that you shouldn't teach it, they knew this was just going to be basically a church versus state case. Now, in response to that, the defense sought out Clarence Darrow, an agnostic, to help out the Scopes case. Darrow originally declined, fearing his presence would create a circus atmosphere, but eventually realized the trial would be a circus with or without him, and he finally agreed to lend his services to the defense, later saying he realized there was no limit to the mischief that might be accomplished unless the country was aroused to the evil at hand. I'll be honest with y'all, I miss the people the way they were in the 1920s. You know, they were passionate. Might not have been passionate about the right things, but they were passionate. After many changes back and forth, the defense team consisted of Darrow, ACLU attorney Arthur Garfield Hayes, Dudley Field Malone, and an international divorce lawyer who worked at the State Department, W.O. Thompson, who was Darrow's law partner, and F.B. McElwee? I don't know. I don't know if I'm not Southern enough to say that. Anyways, the defense also was assisted by librarian and biblical author Charles Francis Potter, who was a modernist Unitarian preacher. I don't know why I cannot say Unitarian. Now, the prosecution team was led by Tom Stewart, district attorney for the 18th Circuit, and included Herbert and Sue Hicks, Ben B. McKenzie, and William Jennings Bryan. The trial was covered by journalists from the South and around the world, including H.L. McKinnon for the Baltimore Sun, who was also paying for part of the defense's expenses. It was McKinnon who provided the trial with the most colorful labels, such as the Monkey Trial and the Infidel Scopes. This was also the first U.S. trial to be broadcast on national radio. So, the trial begins. The ACLU had originally intended to just oppose the Butler Act on the grounds that it violated the individual's rights and academic freedom and was unconstitutional. Principally because Clarence Darrow, this strategy changed as the trial progressed. The earliest arguments proposed by the defense once the trial had begun was that there was no conflict between evolution and the creation account in the Bible. Later, though, this viewpoint would be called the theistic evolution, and they changed their minds on how to go at it. By the way, theistic evolution is the view that God acts and creates through the laws of nature. All right, I actually did not know that until right now, and I kind of get that. So, to support this claim, they brought in 8 experts on evolution. But other than Dr. Maynard Metcalf, a zoologist from Johns Hopkins, the judge would not allow these experts to testify in person. However, they were allowed to submit written statements so that their evidence could be used in their appeal. In response to this decision, Darrow made a sarcastic comment to Judge Ralston, as he did throughout the trial, on how agreeable only the prosecution's suggestions would be to him. Basically, he's saying he only listens to the prosecution. Darrow apologized the next day, but barely kept himself from being found in contempt of court. Apparently, Ralston and Darrow did not get along. Now, the preceding judge, John T. Ralston, was accused of being biased towards the prosecution and obviously frequently clashed with Darrow. At the outset of the trial, Ralston actually quoted Genesis and the Butler Act. He also warned the jury not to judge on the merit of law, which would become the focus of the trial, but on the violation of the Butler Act, which he called a high misdemeanor. The jury foreman himself was unconvinced on the merit of the act, but he acted, as did most of the trial, on the instructions of the judge. Bryan chastised evolution for teaching children that humans were one of 35,000 types of mammals and bemoaned the notion that the human being was a descendant, not even from American monkeys, but from old world monkeys. Sounds like this man is a true old-fashioned racist. Wouldn't have been surprised if he decided to dress up in white robes in his free time. Darrow responded for the defense in a speech that was universally considered the climax of the trial. Arousing fears of inquisitions, Darrow argued that the Bible should be preserved in the realm of theology and morality and not put into the course of science. In conclusion, Darrow declared that Bryan's duel to the death against evolution should not be made one-sided by a court ruling that took away the chief witness for the defense. Darrow promised that there would be no duel because there is never a duel with truth. The courtroom went wild when Darrow finished. Scopes declared Darrow's speech the high dramatic point of the entire trial and insisted that part of the reason Bryan wanted to go to the stand was to try to regain some of his tarnished glory. So basically, Darrow just pulled it out and whipped it on everybody. Because you talk about making somebody look, sound, and feel stupid. This man did it eloquently. Absolutely. As eloquently as you could. And if you've never heard his like the actual speech, go listen to it. This man, you would fear going up against this man. So, the trial continues. And on the 6th day of the trial, the defense ran out of witnesses. Okay? And the judge declared that all defense testimony on the Bible was irrelevant and should not be presented to the jury, which had been excluded during the defense. So on the 7th day of the trial, the defense asked the judge to call Brian as a witness and question him on the Bible, as their own experts had been rendered irrelevant. So now, since the people that they had been tried to use against on the Bible, they're going to call the lead prosecution's person to talk about the Bible. It's kind of actually a good plan. Darrow had planned this the day before to call Brian a Bible expert. The move that surprised those in court, as Brian was counsel for the prosecution and himself, according to a journal reporting the trial, had never made the claim of being an expert, but did have extreme knowledge on the Bible. This testimony resolved around several questions according to biblical stories and Brian's beliefs. This testimony culminated in Brian declaring that Darrow was using the court to slur the Bible, while Darrow replied that Brian's statements on the Bible were, unquote, foolish. So basically, they're just having a good time going at each other on the stand. On the 7th day of the trial, Clarence Darrow took another unorthodox step and called him back on trial. William Jennings Bryan called back to the stand. He still wanted to demonstrate the belief in the historicity of the Bible, and its many accounts and miracles were unreasonable. He's now questioning if miracles are possible and should you believe in them. Brian accepted again, understanding that Darrow would in turn submit to questioning by Brian. So now Brian's going to bring Darrow on the stand after he gets questioned again. Hayes would claim in his autobiography that the examination of Brian was unplanned. Darrow actually had probably spent the night before preparing for it. The scientists the defense had brought to Dayton, and Charles Francis Potter, a modernist minister who engaged in a series of public debates on evolution with a fundamentalist preacher, John Roach Stratton, prepared topics and questions for Darrow to address Brian on the witness stand. By the way, I think it's kind of funny that a modernist minister was on the defense, proving that you should teach evolution. I of all think that is just insane. Curtly Mather, a chairman of the geological department at Harvard and also a devout Baptist, played Brian and answered questions as he believed Brian would in order for Darrow to get ready to question Brian. Ralston had adjoined court to stand in the courtroom lawn, ostensibly because he was afraid of the building with so many spectators crammed in the courtroom. Also because it was 1925 and it was in July and it was hot and it's Tennessee and it's humid. I'm just saying, but whatever. You can blame it on whatever, sir. So, when he began to question him, his area of questioning was really on Genesis. And it really involved whether Eve was created from Adam's rib. How did Cain get his wife? How many people actually lived in ancient Egypt, and questions of those sorts. Darrow used these examples to suggest that the stories of the Bible could not be scientific and should not be used in teaching science, with Darrow telling Brian, "You insult every man of science and learning in the world because he does not believe in your religion." Brian's declaration in response was, "The reason I am answering is not for the benefit of the Superior Court. It is to keep these gentlemen from saying I was afraid to meet them and let them question me. I want the Christian world to know that any atheist, agnostic, unbeliever can question me at any time as to my belief of God, and I will stand and answer him." All right, I mean, I get that. I think that's great that he actually stood up and, I'm here, I'm not cowering from you. As Brian was on the stand, Stewart was the one who objected for the prosecution, demanding to know the legal purpose of Darrow's questioning. Brian, gauging the effect that the session was having, snapped that its purpose was to cast ridicule on everybody who believes in the Bible. Darrow retorted, "We have the purpose of preventing bigots and ignoramuses from controlling education in the U.S." A few more questions followed in the open-air outdoor courtroom. Darrow asked where Cain got his wife. Brian answered he would leave the agnostic to hunt for her. I don't even know what that means. When Darrow addressed the issue of temptation by Eve of Eve by the serpent, Brian insisted that the Bible quoted verbatim rather than allowing Darrow to paraphrase in his own terms. However, after another angry exchange, Ralston called it and adjourned the court. So basically, they never got to finish their own questioning because they couldn't control themselves. Now, the confrontation between Brian and Darrow lasted about 2 hours on the afternoon of the 7th day of the trial. It is likely to have continued the following morning, but Judge Ralston announced that he would consider the whole examination irrelevant to the case and his decision that it should be expunged from the record. So basically, it never happened according to the courts. Thus, Brian did not get the chance to examine Darrow, which I think would have been probably really great. I wish that kind of had happened. Although after the trial, Brian would distribute 9 questions to the press, bringing out Darrow's religious attitude. The questions and Darrow's short answers were published in the newspaper the day after the trial ended, characterizing Darrow by answering Brian's questions with agnostic creed and I don't know. All right, well, that's fine. At least he answered. After the defense's final attempt to prevent evidence was denied, Darrow asked the judge to bring in the jury, only to have them come to a guilty verdict. They found Scopes guilty. We claim that the defendant is not guilty, but as the court has excluded any testimony except as to one issue as to whether he taught that man descended from a lower order of animals, and we cannot contradict that testimony. There is no logical thing to come to except the jury finds a verdict that we may carry in higher court purely as a matter of proper procedure. We do not think it's fair to the court or the counsel on the other side to waste time when we know it is inevitably to be reached, probably for the best result of this case. Basically, they didn't believe he was guilty, but based on the only parts of evidence that they were allowed to use in the case, he was guilty. After they were brought in, the Darrow addressed the jury. We came down here to offer evidence in this case, and the court has held under the law that the evidence we had was not admissible. So all we can do is take an exception and carry it to a higher court to see what evidence is or is not admissible. We can't even explain to you that we think you should return a verdict of not guilty. We do not see how you could, nor do we ask it. Darrow closed the case for the defense with final summation. Under Tennessee law, the defense waived its rights to make closing speeches. The prosecution was also barred from summing up its case, thus preventing Brian from giving his own personal sermon, which I'm glad for. Scopes never actually testified in his own trial, since there was never a factual issue as to whether he taught evolution or not. Scopes later admitted that in reality he was unsure whether he had actually even taught evolution or not, but the point was not contested at the trial. Let that sink in. The actual point of the trial was to know whether a man actually taught something or not, and it was not even brought up in the actual case. Yeah. So, William Jennings Bryan, summation of the Scopes trial. Science is a magnificent force, but it is not a teacher of morals. It can perfect machinery, but it adds no moral restraint to protect society from the misuse of the machine. So, basically what he says is that science is a great thing, but we can't use it to determine how man should or should not act. Further part of his statement, man used to be content to slaughter his fellow men upon a single plane, which is the Earth's surface. Science has taught him to go down to the water and shoot up from below, to go up into the clouds and shoot down from above, thus making a battlefield 3 times as bloody as it was before. But science does not teach brotherly love. So basically he's just saying that you can't use science to make people better. You can make things that they do better, but not people themselves better. So, after the 8 days of the trial, the jury took a whopping 9 minutes to deliberate. He was found guilty and ordered by Ralston to pay a $100 fine, which would have been equivalent to $1,700 in today's money. Ralston imposed the fine before Scopes was given an opportunity to say anything about why they shouldn't impose the punishment on him. After Neal brought the error to the judge's attention, the defendant spoke for the first and only time in court. This is the only time Scopes ever spoke at his own trial. And he said, "Your Honor, I feel that I have been convicted of violating an unjust statute. I will continue in the future, as I have in the past, to oppose this law in any way that I can. Any other action would be in violation of my my ideals of academic freedom. That is to teach the truth as it is guaranteed in our Constitution of personal and religious freedom. I think the fine is unjust. And that was the end of it. William Jennings Bryan died suddenly 5 days after the trial's conclusion. People kind of wonder if the trial and his death were linked in any way. It's debated by historians. I'm going to go with maybe, simply because it was a very high, stressful trial. Which, of course, that's not the end of the trial. The Scopes trial did appeal to the Supreme Court of Tennessee on many grounds. First, they argued that the statute was vague because it prohibited the teaching of evolution, which is a broad term. The court rejected that argument, holding evolution like prohibition is a broad term. In recent bickering, though, it has become understood to mean the theory that holds man is developed from a pre-existing lower type. The second thing that the lawyers argued against was that the statute violated Scopes' constitutional right of free speech because it prohibited from teaching evolution. The court also rejected that argument, holding that he was an employee of the state of Tennessee or a municipal agent of the state. He was under contract with the state to work in an institution of the state. Therefore, he had no privilege to serve the state under the terms of freedom of speech. Wow, that's kind of rude. Third was it argued that the Butler Act violated the Tennessee state constitution, which provided it shall be the duty of the Grand Assembly in all future periods of this government to cherish literature and science. Now, the court also rejected that argument, holding that the courts cannot sit in judgment of acts of legislature of its agents and determine whether or not the omission or addition of particular courses of study cherishes science or not. Fourthly, the lawyers argued that the statute violated the provisions of the Tennessee Constitution that prohibited the establishment of state religion. Religious preference provision in the Tennessee Constitution, which is Section 3, Article 1, states, no preference shall be given by law to any religious establishment or mode of worship. Writing for the court in 2 sittings, 1 year after they received the appeal, they also rejected this argument, saying is that they are not able to see how the prohibition of teaching a theory that man descends from a lower order of animals is given to any religious establishment or mode of worship in any preference. Further, the court held that while the statute forbade the teaching of evolution, as the court had defined it, it did not require the teaching of any other doctrine, and thus did not benefit any religion over one for the other. Nevertheless, having found to be statute of constitutional, the court set aside the conviction of the appeal because of a legal technicality. The jury should have decided the fine, not the judge, since under the state's constitution, Tennessee judges cannot set fines above $50. And the Butler Act specified a minimum fine of $100. Therefore, the only reason the Scopes Monkey trial was overturned is because the judge made an error and gave his own deciding factor as opposed to letting the jury do it. I don't even... Out of that entire case, that's how it ended. That is exactly how it ended. Because it was overturned because of a technicality on a judge. Now, you can still go to the Ray County Courthouse in Dayton and see it. There's actually a plaque that was erected by the Tennessee Historical Commission that talks about the Scopes trial. It is a designated landmark and National Register of Historic Places. So if you're ever in Dayton and you want to see an interesting piece of history that put Tennessee on the map for even just a little while, and maybe one of the few times that people actually knew where Dayton, Tennessee was, check out the Ray County Courthouse and read up on the Scopes Monkey trial. I think that is an important piece of not only Tennessee history, but legal history. Always question your rights. Always question what others are putting on you and saying that you have to do this. And just remember, if it doesn't feel right, that it might not be. Thanks for listening this month, guys. I hope you've learned something very interesting or important, or just giving you a new outlook on life. If you don't know where Dayton, Tennessee is, you kind of do now. It's actually kind of a cool little town. If you're in, Dayton's towards Chattanooga. So if you're ever going towards Chattanooga, maybe make a out-of-the-way little tiny day excursion trip to go see this town that was very important for a week in 1925. All right, guys, be prepared for Christmas. I hope everybody has a great holidays, even if it's not Christmas. There are many holidays between Thanksgiving and the New Year, so whichever one you're celebrating, I hope you guys have an amazing one. All right, guys, stay country.